Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausen Pereira. In a significant verdict, the Supreme Court on Thursday held that a member of an SC/ST community from one state cannot claim the benefit of reservation in government jobs or admission in another state if his or her caste is not notified there. A 5-judge constitution bench headed by Justice Ranjan Gogoi also held that in Delhi, the central reservation policy applicable in jobs of the central government regarding scheduled castes and scheduled tribes would be applicable. It unanimously held that a person belonging to SCs or STs is in one state cannot be deemed to be an SC or ST in other states where he has migrated for the purpose of employment or education, saying that such persons would be eating away the quota meant for the native SCs or STs. The verdict came on as many as 8 petitions that had raised the issue whether an SC/ST community member in one state can seek reservation in another state where his caste is not notified as SC/ST. The bench was also seized of the question whether SC/ST people of another state can seek quota benefits for government jobs in Delhi. On this edition of The Big Picture, we will analyze what the Supreme Court held with regards to reservation for SC/ST persons in states and union territories. Joining me on the program today are S.S. Jyotka, Professor of Sociology, JNU, J. Sai Deepak, Advocate of the Supreme Court, Umesh Sehgal, former Chief Secretary, Delhi, and Ashok Bagaria, Legal Editor, Hindustan Times. Thank you to all my guests for joining me on this edition of The Big Picture. J. Sai Deepak, let me start with you first. Your thoughts on the Supreme Court's verdict?
In fact, I have quite a few questions as opposed to answers myself, and I believe that some portions of the judgment I myself find it very difficult to agree with. See, there are 3 aspects of this particular let's say discussion. In fact, I'll put them under 2 baskets. One is the combined or comprehensive treatment of Articles 341 and 342, which set out the definitions for which community would be an SC and which community would be an ST. The second is Article 16(4). As far as 341 and 342 are concerned, these relate to the domain of presidential orders, where the president notifies with respect to each state or union territory, both being equal as far as this particular issue is concerned, as to which community would be an SC or an ST. So that's one particular issue. Now, this presidential order is immune from judicial review. This is something that nobody can touch upon. At best, the parliament can, and then it has to receive the assent of the president. The second aspect that relates to Article 16(4) is purely in the realm of the executive. Now, there seems to be a serious confusion in understanding the interplay of these 2 sets of provisions as far as I am concerned. The one conclusion of the Supreme Court that I agree with to some extent is to say that since these notifications or presidential orders are only specific to that particular state or territory, therefore that status has been bestowed upon you or recognized only with respect to that particular status or territory. But then the discussion there is slightly incomplete, because under 341 and 342, the definitions apply to all parts of the Constitution, therefore all rights and privileges that are available to you under the Constitution, because it says for the purposes of this Constitution, which means for the purposes of the SC/ST Atrocities Act, if I were to move out of my home state and I go to another state and I am not notified as an SC and ST for that particular state, do I lose the right to lodge a complaint or initiate a proceeding with respect to that? There is a possibility that my question is fundamentally stupid and therefore there is perhaps an obvious answer. But the lack of discussion on this particular issue and the implications of 341 and 342 on this question is slightly disturbing. That's point number 1. Point number 2 is different. Article 16(4) does not find, or there is no reference to the terms SC or ST in Article 16(4) at all. In fact, it refers to any backward class of citizens. That is with respect to the group that it targets. Second, what is the subject matter with respect to which the provision pertains is with respect to reservation for the purposes of employment, appointment for the purposes of the state. Therefore, this has got nothing to do with notification or alteration of the notification by the presidential order through an executive fiat, so to speak, under 16(4). Therefore, 16(4) fundamentally is not a provision which is meant to or can be used to circumvent the presidential order. Unfortunately, the Supreme Court has proceeded under the assumption that these 2 provisions need harmonious interpretation when in fact they don't, because they operate in slightly different spheres. Therefore, there is a possibility that one community which is perhaps an SC or an ST in another state comes to another state, from state A to state B. It cannot obviously get the status of an SC or an ST unless and until there is an amendment to the presidential order.
Right.
But it could be treated as a backward citizen for the purposes of only one purpose, which is appointment under state services. And that is not limited only to SC/STs. It can apply even to non-SC/ST communities because it speaks of backward citizens.
Yes.
And this is a socio-economic inquiry. All these aspects, these nuances, according to me, are completely missing in the judgment.
Right.
Therefore, as far as I'm concerned, it may have answered one question partially, but it has not answered the other aspect. And the second aspect, I think it's got completely wrong.
Ashok Bagaria, would you agree with that? 16.4 and 341 and 342 contradict each other, really?
Well, I do agree with what Sai Deepak just said. In fact, this particular judgment throws more questions than it answers. So, when what the judgment actually does, it lays down a broad principle where it says that if you are a scheduled caste or a scheduled tribe in one state, the benefits and concessions you get in that particular state will not transfer with you if you migrate to another state. So this is the broad principle which they have laid down. But at the same time, they did not look into the fact, as Sai rightly pointed out, that what happens if you say that a particular gentleman from state A goes, who is a scheduled caste, goes to state B. So you are saying by the way of this judgment that you will not be given concessions or benefits for the purpose of employment and education in state B. But what happens to your inherent rights, the rights which are given into the constitution? Do you lose your, see, the whole idea of reservation was to alleviate you from your disadvantaged section, or rather uplift you. So does this mean that suppose one guy goes from state A to state B, is that disadvantage removed? No, the answer is a no. So how do we actually balance that? The only balancing trick the Supreme Court judgment seems to be thinking of is only education and employment, but that does not completely take into account other factors, which are the sociological factors, cultural factors, and many other factors which are not taken into account. So I do kind of agree that this judgment is not complete in itself and it needs to be worked on, and definitely a case for review is made out for this.
Okay, a case for review is definitely made out is what Ashok Bagaria is suggesting. Professor, as far as this judgment itself is concerned, do you see the states tinkering with Articles 341 and 342? They're not allowed to. The Supreme Court too has made it very clear. But looking at the entire gamut of things, looking at what has happened in the recent past, do you see that happening?
See, I think we need to first state this, that this was at some level is just a question of clarification. If you look at reservations or the idea of scheduled caste, it is state specific, and that's how it is kind of included in the constitution. Every state has a separate list of scheduled castes, and these are communities. So identification of somebody as a scheduled caste is based on their community, the family in which they are born, and the kinship in which they inherit. And those kinships can be common. Somebody who is a scheduled caste in Andhra Pradesh may not be scheduled caste in Tamil Nadu with exactly the same identity, same name. Because caste historically, and I think there the constitution makers had a clear understanding that caste is a local regional formation. Communities that exist in Haryana who are Dalits, they do not exist in neighboring states, or they might have a different name, like Valmikis in Punjab and Haryana are obviously scheduled caste, but not so in Andhra Pradesh and Telangana. They are listed as OBCs. So you can have similar names, but their rights vary, or their position or their status, their history varies. Jats in some districts of Rajasthan are listed as OBC, in some other districts they are not listed as OBCs. So I think this dynamic situation needs to be recognized, and I think there the judgment actually restates the point which is already there. Now the problem comes up because now there is also Atrocities Act, which is a different field of kind of, operation. Education and jobs is another kind of area. So these need to be deliberated upon. But the more important point, I think, which has already been mentioned in some sense, that it's a dynamic situation. We are living in one economy, one system, one country. People do have the right to migrate from one state to the other. And once you live in one state for a number of years, you also get domicile of that state. Say a Mahar from Maharashtra migrates to Punjab, she could be an IS officer. Will her children, after 25 years, those who have grown up there, become scheduled caste there in Punjab list? The answer perhaps is no. And that is where I think if you migrate as IS officer is fine, but if you migrate as sweeper from say Punjab to Himachal Pradesh, which actually has been the case, even then you are not included as scheduled caste in the Himachal list. So there are complicated processes, and I think this is something which needs to be also seen as a social process, not simply as a question of legal problems or legal clarifications, because country is developing where people are moving around from one region to the other, one state to the other. But again, reservations are not based on individual. Reservations are based on kinship community criteria, and that requires some kind of identification of boundaries where legal processes can be in some sense imposed and identified. So it's not a simple question, it's a complicated question, and I think it's good that if their questions are being raised, some of these need to be revisited after 70 years of constitution making. But what India was in 1940s is not the same country today.
Right.
So communities also have moved, but reservation is not given on individual basis. It is based on communitarian identity, which is the local kinship community. For example, new Buddhists also, when they are given reservations, they are given on the basis of what community do you come from, community of origin. Before you convert it to new Buddhist, what is your caste?
Right.
And only then they can be recognized as scheduled caste, not where I'm a Buddhist and therefore give me a scheduled caste status. That is not the way it is. So
Right.
I think there is an inherent issue in it. So since it is community based, those communities are local and they are region specific and they are operationalized at state specific. So this question is actually, the way Supreme Court has clarified at some level is just a clarification. It's already there. But now, given the situation of migration, given the extension of the SC/ST Act to atrocities and other points that have been made, it kind of raises other questions, which I think valid question. India will have to deal with them at various levels, both at legal level, but also at a sociological and political level.
Several valid questions arise as far as this verdict is concerned, and in the way India has developed as well since the 1940s, is what Professor Jyotka is suggesting. Mr. Sehgal, considering that this is a complex issue, it's complicated, how do we uncomplicate it really going forward?
It's quite simple. I will not go into the legalities of the thing because the highest court in the country has decided the legality. Now we can go back and review, we can go back and appeal, we can amend the constitution, that is different. What they have said is that you have to be fair to people in all the states. Now let us take small states in the northeast and let us say a state like Lakshadweep, where there is a very small population and all are scheduled tribes. And they are scheduled tribes only because they were born and brought up there. Now, if scheduled tribes in other states, especially in the northeast, are recognized in Lakshadweep also, where will they go? Where will the locals go? It will be very unfair to the locals to be treated like this. The second aspect here is that in the union territories, they have made a clear distinction. So they have not decided for other union territories apart from Delhi because they are governed by the central government. Since the central government is a government common to all the states, so they have said all the states, the scheduled castes in all the states or scheduled tribes in all the states will be recognized for jobs under the central government. And which they have also said the Delhi government. Now that may be a little unfair to the people of Delhi, but there is a clear decision that these are also central services. So in states like Danix and Das, there can be no distinction for, let us say, scheduled tribes from northeast. So if northeast, if some Naga or if some Manipuri wants a job in Danix or wants a job in Das or wants a job in the Delhi police, he will not be discriminated against because this is part of a central government. But this is not the case if he goes to UP or if he goes to Tamil Nadu, because there are scheduled tribes there. Those scheduled tribes have a right to jobs, and reservations have been made in relation to the percentage of people available in a particular state. So I think the Supreme Court decision is fair, is just, and it is absolutely correct, and we should accept it in the spirit in which it has been given. And we can question the legality, we can go on doing this, because there has to be an end to the debate at some level.
Right.
I know this debate was going on for quite some time, especially in Delhi, where jobs cannot be filled up because there is no scheduled tribe in Delhi. So, but here, the Supreme Court has now made it clear that scheduled tribes in any part of the country can come and take jobs in Delhi. Now that's a wonderful decision. I think that decision should be implemented in the right spirit, and it will help scheduled tribes, especially in the smaller states
Okay.
like Lakshadweep Islands or like the Northeast, where the population is very small, but the percentage of tribals is very large.
Right.
So I think we should accept this decision, and I personally welcome it.
All right. Taking the discussion forward now, let's get into specifics. Sai Deepak, what happens if a particular caste is notified in state A and state B, and a member of that particular caste who is a domicile of state B but applies for a job in state B, where his caste is notified there as well? What happens then?
See, here the Supreme Court's reasoning on this particular issue is clear. To that extent, I agree with what the Supreme Court has said on this limited question, which is the Supreme Court goes on to narrate the sequence of events in terms of how castes were identified in the pre-British times, and then how the exercise was undertaken under the Government of India Act of 1935 and subsequently also, and goes on to clearly says, and I think I completely endorse what the professor has just mentioned, that this is an extremely localized phenomenon. Therefore, notwithstanding the fact that you may have a certain caste which is notified in one state and the same caste with the same name is notified in another state, the question is, was it meant, or the notification of the subsequent state, was it meant for you? That was the first question. Therefore, on that particular issue, the court goes on to say, in state A, assume that there is a caste X which is notified. In state B, there is a notification for the same caste X. You do not ipso facto become part of this particular caste X, notwithstanding the same nomenclature, because it is not on the basis of nomenclature, but your position in the socio-economic ladder that this notification has been made. That's point number one. Point number two, there are two considerations here. One, assume that there are 100 posts in this particular state B where you have migrated into. Out of this, let's say 25 posts are limited or reserved for SC/STs of that particular state, and 85 posts or 75 posts to the others. If others from, let's say from state A migrate into B, they eat not just into 25, they also eat into 75. Therefore, two sets of people are affected by this particular migration. If by the mere factum of migration and the mere factum of the nomenclature existing in state B, you become entitled to this reservation. That logic I agree with. To that extent, I'm absolutely clear about it. And this issue, as far as I'm concerned, is not an invention in this judgment. There have been 3 judgments previously. The Murray Chandrasekhar Rao judgment, the Action Committee judgment, and the Subhash Chandra judgment. The judgment that created subsequent trouble is the Pushpa judgment from Pondicherry. Then a few more judgments. But other than that, the position, as Sir rightly points out, is a reiteration of the position as existed before, which is crystal clear from the language of the provisions itself. Now, the one thing that we have to consider here is this. And just for the sake of clarity, I was going through the Prevention of Atrocities Act. There, the definition of SC/ST is the definition that is attributed to it under Articles 366, clauses 24 and 25. If you go to clauses 24 and 25, Article 366, it refers to Articles 341 and 342. Therefore, you're an SC/ST as far as the Constitution is concerned for all practical purposes, if you're an SC/ST under Articles 341 and 342, which again goes back to the presidential order. Therefore, it is again state-specific. This aspect, according to me, is an extremely important aspect, considering that the SC/ST Atrocities Act has been fresh in our public memory, considering what has been going on before the Supreme Court. Therefore, one would have thought this balancing act could have been done. Therefore, to the limited extent that it explains and reiterates Articles 341 and 342, I don't think there's an issue. The problem is with its extrapolation to the Atrocities Act and the unnecessary conflation of the object of Article 16(4) with the object of Articles 341 and 342. That is perhaps where the grey area lies, and that is where a review is called for. Most importantly, you have to understand that this is not just social, legal, or cultural. This is at a very important level, it's political. Notifying or denotifying a particular community in the presidential order as an SC or an ST is affecting somebody's political arithmetic. Therefore, it is a question of political will as well.
Talking about politics and talking about political will, Ashok Bagaria, what happens in a reserved seat? Now, say for instance, a candidate contests in a particular seat, a reserved seat, but contests in Punjab, but is from Rajasthan. What happens then? Is it null and void?
Yeah, that is again a question which remains unanswered by this judgment. But going by the practice which we follow at the moment, the particular scheduled caste candidate who goes from one state to another will not get the benefits of reservation in that particular state.
What if that caste is notified in that state as well?
Even again, despite being notified, this particular gentleman who migrates from this place to that place will not enjoy the benefits of reservation. But again, you see, at the root of the problem lies the process of identification. You know, how do you identify a scheduled caste or a scheduled tribe? The process which has been followed so far in our country is local, or rather state specific. So if I am a scheduled caste and I come from a particular state, then I will be a scheduled caste. But the problem here is that I am a scheduled caste not because I am from a particular state. I am a scheduled caste because I was born into a particular family by birth, because my parents or forefathers practiced particular profession, because of the whole caste structure which prevails in this country. So those factors have not been taken into account, or even if they have been taken into account, they have been confined only to a particular geographical region. So what you do is you identify a particular person or a particular community and say, oh, for purposes of this, you will have to remain confined to this geographical area, which I am not really comfortable with, because I believe that when I'm not a particular citizen of a state, I am a citizen of this country.
Yes.
So I should get the benefit of reservation throughout the country. However, there are differences.
It's a different debate altogether. Do we need reservation or not? But yeah, when it's there, it might as well apply everywhere.
Right, everywhere.
Yes, Sai.
Just one point. Perhaps the court could have considered the possibility of striking a distinction between reservation for the purposes of central services and state services, and then said that this logic of 341 and 342 perhaps is limited to reservation with respect to state services. But no such distinction is struck. Because as far as I'm concerned, for the government of India, you are an SC, whether or not, whichever state you come from. For the state government, perhaps you're an SC or not an SC, depending on which state you come from. So for the purposes of central posts, for the purposes of central teaching posts or appointments or whatever it may be, perhaps you may have to adopt a different position or a different approach altogether. That I don't find a discussion at all. It seems like for an invasive surgery which requires a precision instrument, somebody's taken the sledgehammer to the place.
All right, Professor, we've spoken about central services, we've spoken about central jobs. What about central universities and the education system?
So I think this problem, according to my understanding, does not exist. For example, for admissions to IITs, you have a central list, and that central list you also submit your certificate. Or for example, if you're applying for IAS, nobody is asking you which state cadre you are going to be allotted. It's only once you are selected under SC, after that your state cadre is going to be allotted. So I think there are areas where there is no dispute, there is no problem. But I think the problem is because ground reality is changing. And for that, also one should recognize that caste is, or all social realities are dynamic processes. They are evolving, they are changing, they are shifting. And context becomes very important. I think the point that was made by a gentleman earlier, there are states where communities are very small and they have their own specific realities. Or for example, I was doing research in Himachal Pradesh. Now, Kinnaur region, everybody is a scheduled tribe because it's a scheduled area. So everybody gets ST status. Now there are Rajputs there, they get ST status, and there are Dalits there, they also get ST status. They agitated and then they were allowed that you can also claim SC status. So state processes have also been flexible to local situations and local contexts. And I think that is the response. At some level, these are things that cannot be tinkered with. But at another level, I think you have to be context specific. And that's why we need a constant reflection on caste question. In a textbook understanding and also some kind of legal understanding, caste is seen as a static pan-Indian system with notion of Varna hierarchy. This is not how the reality is. And I think people who framed our constitution knew the reality on ground and they worked it out in a very nice manner. I think in that spirit, we need to look at the realities the way they are changing. Migrations, who migrates, who does not migrate. And migrations are a reality. Again, what context, where do people migrate? If there is en masse migration in a particular region of a particular community, which could be a dominant community, or when they migrate to a different region, they don't experience any discrimination and they become dominant community even though they were scheduled caste or scheduled tribe in one community. So these also become very powerful communities. And some communities have over the years become very, very powerful in their own, and they don't need reservation. So I think there is need for some kind of active engagement with the ground reality of caste, the way it is changing. And that space does not exist, because the moment you talk about caste question, then you have a specific kind of narrative which takes over and nobody can touch it and nobody can. So one needs to, and these questions have come from within. Like, for example, quotas within quotas. This is not something that has come from outside, and these are real questions, right? You have in Andhra Pradesh, Mala Madhika question. In Punjab, you have category 1, category 2, other states also. These are realities which are very, very complex and they are constantly changing. And this migration also becomes very significant. Delhi, again, you have Delhi state and you have Delhi state jobs. And then you have central government jobs. And Delhi is not the only union territory, the other union territories also. If it applies to Delhi, will it also apply to Pondicherry and Mahi?
That's
so
interesting.
I think these are very important questions
that's
which
interesting,
need to be localized, contextualized, but also with a perspective.
That's very interesting. Mr. Sehgal, where does this leave Delhi really? There seems to be a distinction amongst the union territories as well, and it seems like the national capital territory has lost out.
Well, I won't say it has lost out or anything of the sort. What it says is that this is the national capital and it is the union territory. So the services here are part of the central services. These are really all India services. So there will be no reservation for Delhi alone. There will be recruitment on an all India basis. That has been the position, accepted position so far. They have clearly said that as far as other duties are concerned, we are not dealing with the issue, so we leave that aside. They have not given a clear ruling on what will happen in the other union territories. I suppose every union territory has a separate act, so the position will be decided as per those particular acts which they have there. But as far as Delhi is concerned, this has been a burning issue. Services our services are part of the central government or part of the state government. Now here is a bench which was not really dealing with the issue, which has already decided that this is part of the central government. So central services are central. There is another bench going on the same issue. Let's see what they decide. I will not say, but I think it is a decision which is fair to Delhi, because Delhi is not a state like the others. It had a population of only 9-10 lakhs in 1947. So all the people here are through migration, and either during the earlier period or now. Okay. And a large number of people here are working from all over the country. They are not just natives of Delhi. So I think the Supreme Court has very correctly decided that it does not apply to Delhi.
Right.
But it applies to states. As far as other duties are concerned, they have not decided anything.
Sorry to interrupt, Mr. Sehgal, but Delhi is a special case, is what you're suggesting. Your points are taken. Ashok Bagaria, you wanted to add something?
I just wanted to add something, that as far as the reasoning for Delhi is concerned, the judgment clearly says, and it says that by Article 239AA, a special status was given to Delhi, and it was not, the union territory status was taken away from it. And it was said that it will be the national capital region or the national capital territory, whatever it was. But another very important thing, as far as the court is concerned, the court never said that all services which are under Delhi government are central services. But they have applied the pan-India reservation rule to Delhi for one reason. The reason is that Delhi as a place does not have its own native population. The majority of the population in Delhi is migratory. So in a sense, if we are to say that we have native scheduled castes and scheduled tribes in Delhi, that's not the case, and probably that's what weighed with the court while saying that pan-India reservation rules will apply to Delhi.
Right. Sorry.
Can the same logic be applied to a cosmopolitan city like Mumbai?
Yeah, that's a bit complicated.
Because at the end of the day, as far as Mumbai, Bangalore and IT hubs are concerned, they have a huge migratory population today. You'll find Tamilians in Chandigarh today and Punjabis in Tamil Nadu today. So what are we going to do about it? If that be the case, perhaps...
The concerns then raised by Justice Bhanumati, it was not unanimous as far as Delhi was concerned.
She disagreed completely on the aspect of Delhi.
Disagreed completely. Are those concerns justified?
I would say so, because I don't think, and as Professor Jodka has been hitting the nail on the head constantly, which is to say that the migratory pattern and its influence and its impact on the presidential order itself needs constant revisitation. That is something that we need to consider.
30 seconds, Professor. Close the show for us.
Yeah, precisely. I mean, we need to have institutional process to deal with it. It cannot always go to the court. Institutional process in the sense like you have SC/ST commission, there should be cell within SC/ST commission or a separate cell that deals with these questions. Right. That how do you identify a community once it requires large number of population and they are living in Delhi and they have been here for last 20 years, but what level have they migrated? They have migrated as sweepers, then they can be given that status and they all identified as community.
I've got very limited time on the program. Mr. Sehgal, close the show for us with your concluding remark.
Well, my concluding remarks are, I think it's the right decision. As far as the smaller states are concerned, as far as the larger states are concerned, there's enough opportunity for the locals there. If they want jobs, it is a question only of jobs. It is a question of government jobs. I don't think they have decided educational issues and other issues in whatever way. As far as jobs are concerned, I think it's an extremely fair decision, and I think we should not even go for reviews, and we should implement it if we want our minorities and smaller states not to suffer.
All right, on that note then, we'll call it a wrap on this edition of The Big Picture. I hope we've been able to answer some of those several lingering questions as far as the Supreme Court's verdict on this particular issue is concerned. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.